So this morning, I'm talking to Mr. Kevin Tan, an adjunct professor of law at the National University of Singapore and the Nanyang Technological University in Singapore as well. He is widely regarded as a constitutional expert on Malaysia and Singapore and has written many, many books on this issue. So thank you very much for coming to my podcast, Kevin.
Thank you, James.
So I wanted to ask you the issue about Malaysia agreement. I'm sure you're aware that there are many, many groups in Sabah and Sarawak who are unhappy about this issue. And
Yes.
a lot of them have the starting point that the Malaysia agreement is an international agreement. So they're arguing that because people are unhappy and the state of federal state relationship has not been going well for the past half century, perhaps they should seek a legal remedy. So I wanted your opinion. Is it possible to litigate Malaysia agreement under international law?
Well, let me begin by describing the nature of the Malaysia Agreement of 1963. If you look at the signatories of that particular agreement, you would find that there are representatives from the Federation of Malaya, the UK government, the state of Singapore at that time, right, self-governing state, but nonetheless a colony of the United Kingdom, and then again representatives of Sabah and Sarawak. Now, if you only look at the signatories to any agreement, you assume that whoever signs has authority to sign, right? I mean, otherwise, why in the world are you signing this? But if you try to understand the nature of this kind of an agreement, the real agreement is between the governments of the United Kingdom and the government of the Federation of Malaya, just two parties. Because under international law, if you are going to sign this kind of an agreement, it would need two sovereign states. And of course, Malaya had already become independent in 1957, so Malaya is a sovereign state. United Kingdom, obviously a sovereign state. So the two of them can, of course, enter into an international agreement. So that begs the question, what in the world are the representatives of Singapore and Sabah and Sarawak doing in this? Now, there are various arguments for and against. From a legal perspective, it does not add substantially to the legality or to the terms of that agreement. It doesn't, right? Because if the agreement doesn't work, in other words, okay, so lawyers will always think of the worst case scenario. So if the agreement doesn't work, then the question must be, who can take action against whom, right? So let's say that under the agreement, certain things were supposed to be done in respect of, say, the federal constitution, and they were not done, or they were done in a way which violated the terms of the agreement. Then the action would be the UK government taking an action against what was then the Federation of Malaya government, and basically taking them to task, right? Whether you can bring this to the ICJ or not, well, that's another story altogether, because neither United Kingdom nor Malaya at the time, I think, were subject to the compulsory jurisdiction of the International Court of Justice. So, and this is how the system works. You can't just drag anybody you like to the International Court of Justice, because the statute of the International Court of Justice provides for both compulsory jurisdiction and optional jurisdiction. Compulsory jurisdiction is where if you sign on and you say, well, I'm amenable to the compulsory jurisdiction of the ICJ, anybody can take me to court, and I have no choice, right? This is exactly what happened in 1986 when Nicaragua took the United States to the ICJ, and they went kicking and screaming. In fact, they didn't even turn up because they were very, very unhappy. I think not having realized the implications of this compulsory jurisdiction. However, most other states opt for the optional jurisdiction. In other words, unless the parties agree, you cannot go and invoke the jurisdiction of the ICJ, which is why in 2006, when Singapore and Malaysia decided that they would litigate the Pedro Branca case, uh, it was done by way of a special agreement, and that special agreement between the two states stated that they would submit this dispute to the International Court of Justice, and they would therefore be amenable to the jurisdiction. They would submit to the jurisdiction of the ICJ, and that's why the ICJ could rule on that case, right? And the case is therefore binding. So let's come back to Malaysia Agreement 1963, right? Uh, 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 was the state of Singapore independent at the time? No, it wasn't. Neither were Sabah nor Sarawak. So they technically are not parties to the agreement. It would have been the United Kingdom as the colonial power acting on behalf of these territories, these three territories, and in a way acting sort of as a trustee for these territories in engaging with the Federation of Malaya. Okay, so if we go back to the legal implications, can you litigate? Well, uh, forget the question of what you want to litigate first. But if you want to litigate, there are only two parties that can be in the equation, and that would be the two states, the United Kingdom on the one hand, and uh, uh, the hitherto uh, government of the Federation of Malaya. Now that makes things really complicated because the Federation of Malaya after 1963 doesn't exist as a political entity. It is now the Federation of Malaysia, which already incorporates, the territories of Sabah, Sarawak, and for 2 years Singapore. So if you want to use that as the basis for litigating your unhappiness, I think the train has kind of left the station. Uh, uh, and in any case, you've got to see what was it in the Malaysia agreement that you are unhappy about. The terms of the agreement are extremely brief, as you probably know. It's a very thick agreement. But the reason it is so thick is because it incorporated the state constitutions for Singapore, Sabah, Sarawak, with all its annexures in it. In other words, there were draft constitutions built into the Malaysia agreement. The agreement itself is maybe, I don't know, 7 pages or something. It's not very, I mean, depending on what font you use and so on, but it's not a long agreement. Basically says that from Malaysia Day onwards, these territories would now form a new entity known as the Federation of Malaysia. And then what are the sort of interim things that need to be done in the meantime? So yeah, I mean, if you want to look back at MA63 for the purposes of litigation, I think that's probably not a very helpful way to start.
What about in the domestic Malaysian laws? Can you litigate under domestic Malaysian laws, for example, in terms of federal state relationship and a 3 schedule list?
Of course, of course. This is the whole idea, right? So, if you are unhappy with the terms, now here again, what are the terms? And I maybe it's a worthwhile time to go into this question of the status of the 18-point and 20-point memoranda
Mm.
that were drafted pursuant um, to Sabah and Sarawak coming into Malaysia.
The so-called safeguards.
Let's leave Singapore out of the equation
Mm.
because Singapore went in and came out, and it was a done deal. It was facilitated uh, by the governments of the two countries. There is no clause in the Federation of Malaysia Constitution that allows for secession, even though the right to secede was clearly something that was built into the memoranda, right? The 18-point, 20-point memoranda did talk about the right to secede. And that's why, when I go to Sabah and Sarawak and people find out I'm from Singapore, they will always say, hey, we should have left along with you. But that's a totally different story altogether. So let's get back to the question of uh, the um the 18 and 20 point agreements. What is their status? Do they form part and parcel of the constitutional document? Answer is no, it doesn't, right? It doesn't. Uh, they were concerns that were raised by the two states, uh, and safeguards that they required as conditions for their entry into Malaysia. Now, as far as I can see, um, most of those points had actually been taken into consideration in the draft of the 1963 Constitution, right? So, so for example, religion. Um, 63 constitution basically divided the powers of the federation into those that are accounted for by the federal government and those by the state government, and religion was always a state matter, which is why, I mean, speaking from a Singapore perspective, Lee Kuan Yew had absolutely no issue with Article 3 of the federal constitution that states that the federal, Islam shall be the religion of the federation, because it had no legal impact. The ones who control all matters relating to religion were the states, right? Which is why you have this thing where states have their own Sharia courts, and there is no sort of a centralized federal Sharia court. So religion is a state matter. Now, what happened with the fact that you did not want to have Islam as a state religion change as a result of politics and legal maneuverings, rather than anything that happened in 1963. So at the start point in 63, it was still okay. In other words, the people in Sabah and Sarawak had absolute say over matters of religion, and whether they chose to have a state religion or not have a state religion, or how they wanted to manage religious affairs, was entirely a state matter. So at that point, at the inception, there was really no problem, right? Problems arose later. So as with all legal documents, you don't expect them to be frozen in time. Uh, there are provisions in the legal instruments which provide for change. So constitutions can be changed, right? Now, there are, of course, some countries that have what you call eternity clauses. In other words, can never be changed, right? So one of these big debates in Japan, for example, right now, is actually over Article 9 of the Japanese Constitution, that basically makes Japan a pacifist state, and whether that could change or not. Big debate, right? But in some other countries, you may have eternity clauses. But as far as I can see, the Federation of Malaysia Constitution has no eternity clauses. So everything is changeable. Likewise, if you look at the state constitutions of Sabah and Sarawak from 1963, there are no eternity clauses, right? So if you follow the established procedures laid down by the Constitution, you meet whatever criteria is necessary, you check all the right boxes, you would have effected a constitutional change. Now, this is not a bad thing, because if you have a constitution that cannot be amended for a very long time, it either becomes uh, dead letter, because it is no longer relevant to changing circumstances, or you may require a very imaginative and creative court, like the Supreme Court of the United States, for example, to constantly interpret and reinterpret the clauses of the Constitution in a way that would fit uh, uh, situations, everyday situations. But I don't think you could, no matter what you do, you could never interpret those old constitutions, the 63 constitutions of Sabah and Sarawak, in a way that would suddenly give you an official state religion. No, that had to be done through the respective legislative assemblies, right? And this was done. So was there an illegality involved? Well, from the legal point of view, no, the legalities were met. Uh, were there political maneuverings? Well, that's another story altogether, and that's not something I suppose a lawyer is allowed to speculate, right? Um, yes, but of course, if the things were done in a way which somehow breached the law, the procedures established by the law, whether it is even by way of deception or the way in which they crafted particular resolutions, well, those can be argued. Those can certainly be challenged.
Why do you think there's so few case law in Sabah and Sarawak? How come people have not tried to litigate on this issue?
Well, that's the difficult question for me to answer, because I imagine that it is the nature of the politics for a start. I mean, who would take up an action on behalf of Sabah and Sarawak as the state? It would be the state governments, right?
Mm.
So basically, if you're going to challenge the federal constitution, any particular provision, right? For example, where you think that the federal government has, say, legislated in a matter which was reserved strictly for the states and should never have been allowed to do so, you can, right? So, in fact, right at the beginning, just before Malaysia Day, the state of Kelantan took out an action against the federal government for failing to consult Kelantan on basically the creation of Malaysia and the subsequent demise of the Federation of Malaya, right? But of course, that was overruled. But it actually went all the way up to the federal court, right? So it would be a state government on the one hand taking out an action against the federal government.
Mm.
And it's not as if that has never happened. It's just that it all depends, right? So if you are being run in a state, I mean, in the state, if you have a government that is from the same political party as the
Federal government.
federal government, I mean, you don't commit political suicide by suing your own colleagues.
Sure.
I
Is it
imagine, right?
possible for the activists or individuals to have the local standby to sue the federal government?
Um, Possible, of course, it's always possible, right? So, but this would require, and here I'm just speaking from a purely legal point of view
Sure.
as opposed to anything else, right?
Yep.
In
Your
other
opinion.
words, the matter would have first have surfaced to the extent that um, the activists have pushed their point home first to the state government. So if the state government is prepared, not prepared, right, to do it, it simply just refuses to take such action, then it's possible to go direct to the federal court and file a judicial review. Of course, it's possible.
Mm.
Now, matters of local standi are strictly within the rules of the court. So, in other words, the court will decide whom it will hear and who it will not hear, right? So locus standi, which is standing
Mm.
or the right to sue, uh, is a very tricky business. Uh, the courts adopt a public policy view that you don't want all kinds of crazy, spurious claims against the state, right? You've got no time to be dealing with this. The state has got to run, the government's got to do its job. We don't want vexatious litigation, senseless, vexatious litigation. So how do you stop that? Well, you put a bar. So one of the bars that the courts have typically used, and this is not just Malaysia or Singapore, United Kingdom, there's one of these bars, is that you should exhaust local remedies. That's why I said you need to go through the whole process in the state first and say that, well, the state just won't give me a remedy, but the state refuses to act. The state Attorney General refuses to take up the case. Well, okay, if you can show that kind of a paper trail, right, then the court will not be able to object on the basis that you have not exhausted local remedies. So that's one barrier which the the courts typically put up. Secondly, they will very often require you to show some kind of interest in the matter. In other words, you should not be some busybody, some nosy Parker coming in and saying, well, hey, why aren't you doing this, right? So you must show some kind of special damage. In other words, you yourself have somehow suffered from this. So that's not hard to show in most cases. So if, for example, you're planning to litigate on, say, the Petroleum Development Act, right? Then you can say, well, hang on, this money should have been mine. I should not have had to pay that much taxes, or I shouldn't have been able to have uninterrupted electricity supply in my village, or whatever, right? So long as you show that you are somehow personally affected, not that you are some NGO sitting in New York and then saying, hey, something's wrong, litigate, right? You must show special damage. So usually these are the kinds of barriers that the courts would put up.
So my final question,
yeah.
So my final question is, following up on what you said about the PDA, Petroleum Development Act.
Yes.
As you know, many people are in Sabah and Sarawak are saying that one of the reasons they're very unhappy is that oil and gas resources will sort of siphon off from these two states and transfer to the federal government. And the federal government only give 5% royalty, which is very little, while Sabah and Sarawak is very, very undeveloped. The argument put forward has always been that the chief ministers of both states did not have the authority to sign the PDA, and the PDA was signed without the permission of the State Assembly. And moreover, the PDA was basically forced upon Sabah and Sarawak by the federal government. What is your legal opinion on this?
Okay, hold on. First of all, the PDA is a federal statute. Okay, so they didn't need to go back to the state, ostensibly. But if one goes back to the Federation Constitution, it seems to me pretty clear that if you look at the state list under the 9th schedule, right, it says very clearly that where except for Federal Territories Labuan and Putrajaya, all permits and licenses for prospecting for mines, mining leases, certificates, matters relating to land, transfer of land, are all strictly state matters.
Yes.
Okay? Then you say, well, does that correspond with anything else in the federal list? Okay, so let's go back to the federal list. And the closest thing I could find was in section 8J of the federal list, right? Where it also talks about, mines, minerals, and so on, except that 8J actually says subject to item 2C in the state list, which is what I just read you just now. Development of mineral resources, mines, mining, minerals, mineral ores, oils and oil fuels, purchase, sale, import, export minerals, etc., is in the federal list. So they are saying that subject to what is in the state list, I take charge. Okay, so then therefore takes us back to the state list, right? Is the state list enough to cover questions of mining and so on? And I would say that just based on the wording, it would appear so, right? It would appear so. In other words, back in 1974, well, actually, it could have been 74, it could be now. An argument could be made to say that the federal parliament had acted ultra vires, it acted beyond its powers, or acted unconstitutionally by passing an act like the PDA, right, which gives jurisdiction to an oil company over sort of these state assets. I'm just kind of summarizing it. And that's an argument that could be made, right? But I could not find any constitutional challenge raised by anybody on this.
Mm,
But maybe I haven't looked hard enough, but I couldn't see a constitutional challenge to the 1974 PDA. So
mm, mm, mm.
maybe
No,
maybe
no, I
people
think
thought
you're
about
right.
it.
Nobody is actually sued on the basis of PDA. A lot of current lawsuits has been about either the royalty issue or the type of payments in terms of royalty. And Sarat recently took Petronas to court over the issue of the 5% sales tax. But again, they're not part of the whole PDA. It's just
Well, you see, the trouble is now if the PDA or those relevant provisions of the PDA pertaining to sovereignty over the
oil and
state
gas.
assets,
Yeah.
uh, if that is unconstitutional, then there is no power on the part of Petronas or the state government to enter into any subsequent agreements.
Mm, 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 mm,
Yes.
mm,
Um, but but of course, if the state itself now here, if the state itself has determined that the only way it is going to manage its oil resources is to tie itself or hitch its wagon to Petronas, and you sign this 5% agreement, then there's nothing I can say.
mm. Yes. Okay. Well, again, Kevin, thank you very much for spending your valuable time with us. I think we've learned a lot, and I think you've raised a lot of issues and also clarified a lot of issues on this issue MA63. So thank you again for taking the time.
You're most welcome, James.